to this special. You're welcome to the specialist program webinar series organized by the Chartered Institute of Arbitrators Nigerian branch. Today, we are going to be discussing bankruptcy and insolvency disputes, risks, resolutions, and recovery. It's our delight to introduce two of our erudite speakers today. One of them will be joining us shortly, and we already have one of our speakers present here. He is Mr. Seyi Akewumi. He is a past president of the Business Recovery and Insolvency Practitioners of Nigeria. Not just a past president, but one who, before his presidency, had served as the General Secretary of that body, a position that I'm now privileged to occupy. He has also made several contributions in that field, particularly in the field of insolvency. And today he's going to bring to us some depth of institutional insights and practical experience on this topic. So join me in welcoming Mr. Seyi Akewumi, who is also the partner and founder of Akewumi and Busari LP. Mr. Akewumi, are you there?
Yes, I am. Thank you very much, Efosa. It's sort of going off. So, yes, it's my pleasure to be here. And hopefully we can have a robust interaction this morning into the afternoon. Thank you very much.
Thank you. And our second speaker who will be joining us soon, I would not want to break the conversation too much. That's why I'll be doing the introduction before he joins, is Leonard Sik, who is also a past president of, or would I say the immediate past president of BRIPAN, which is the Business Recovery and Insolvency Practitioners of Nigeria. And he is Mr. Chimeze Victor C. Yekwazu, SAN. He will be joining us soon. He's also someone who has served as General Secretary of that same body, a role that I'm currently occupying, and he's renowned for his insolvency work. And I would say his perspectives has also helped reversionalizing the insolvency space. And I'm very sure and confident he would also be able to bring valuable insights to our discussion today. So without wasting our time, I would go straight into our discussion. And I will start with Mr. Seyi Akewumi, who is with us here, to give us an insight as to, or would I say an introduction, because for the sake of those of us who are here who do not have or are not exposed to insolvency practice, it would be good for us to start from the basics. And I would want Mr. Akewumi to just briefly give us an explanation of what bankruptcy and insolvency mean. At least if we have that basic knowledge, it would help us to better understand the conversations that we'll be having this morning. Mr. Akewumi, please.
Right. Yes, I'll put my video on and hopefully you'll still be able to hear me. I think that first of all, thank you again for inviting me to this. Really, in terms of when we speak of bankruptcy and insolvency, these terms are often used interchangeably, but they actually carry distinct legal meanings, particularly under our law. So, insolvency is a financial condition. And I'd like you to note that it's a condition that, and it describes the state of a person or an entity that is unable to pay its debts as they fall due, or whose liabilities exceed its assets or his or her assets. So it's a factual and economic state. a company can be insolvent without any formal proceedings being commenced against it, no receivership, no administration, no liquidation, but it may be insolvent. Bankruptcy, on the other hand, is a status. Remember, I said that insolvency is a condition. So bankruptcy is a legal status. It's a formal process by which a court declares an individual. And the difference here, not a company. In Nigeria, it's only applies to individuals, by which a company declares an individual unable to pay its debts. So you may be insolvent because you can't pay your debt, but you're not yet bankrupt because you have not been declared bankrupt. So when the court declares the person bankrupt is when the person becomes bankrupt. When I say person, I mean natural person. So the law in Nigeria is governed by the Bankruptcy and Insolvency Act. I think it's 2016. We used to have an old act in 1979, which was hardly used. I don't think that the BIA itself is used as much as other legislations. But yes, so that's really the difference between the two. So in summary, the insolvency is the condition, while bankruptcy is the legal status and the legal remedy. It depends on how you use it and who's using it. So you can have winding up or business rescue is a legal remedy, but bankruptcy is just to the natural person. Thank you.
So, sir, given your explanation, can you in simple terms just explain to us if the terminology insolvency and business rescue, if they are either the same or they are it's just the terminology. We need to know if they are the same when the situation arises and when we can say we can explore the options. So what options does CAMA really provide for us? Can we use these words at the same time, or they are actually they have separate meanings?
Well, first of all, as I said, insolvency would be a generic term. So you may be insolvent either as a person, but usually as a company. Under CAMA, it's essentially a company. In grammar, it can be a person or a company, but under CAMA, it's usually a company. So, but you can be insolvent, but and not be bankrupt. But of course, if you're bankrupt, it means you're insolvent. And when it goes to the issue, you also raise the business rescue. I think insolvency and when you compare that to business rescue, the fact of business rescue clearly tells you are dealing with companies. And therefore, in layman's terms, or let me give you an analogy. Somebody's ill and in hospital. And that actually is what led to the name change from IPAN to BRIPAN. So is insolvent. So the patient is the insolvent person. You can leave that person dies and you bury that person. Or you can try and resuscitate that person and try and give it, oxygen, give it medicine, put it on life support, various options that you have. And that is the equivalent in this sense when we're talking of business rescue. So in the old days, insolvency practitioners were seen as undertakers. But as things have gone on, they have taken a new dimension of trying to rescue a business. And that's where administration has now been put to the fore in CAMA. So the people are trying to move from receivership and liquidation to administration, so you can try and see if there's a way you can turn the business around. Thank you very much.
Thank you so much. So while you were speaking, Mr. Akiwumi, the Leonard Silk, Mr. Chimeze Ikwazu joined us. I don't know if he's ready or he needs to catch a breath. So once you're ready, Leonard Silk, you can put on your video, then I would come in with your questions. Okay, yes, it shows you're ready. So thank you for joining us, and we apologize to our audience that it had some bit of glitch with interconnectivity glitch, but he's here with us. So we will get right on into the conversation. Leonard Silk, sir, Mr. Akiwumi was just briefly telling us in layman's terms, particularly for those who are not exposed to insolvency, the difference between bankruptcy and insolvency. And he also tried to explain to us that when we can use certain terms as to when the rescue options are available and when the terminology insolvency can be used, which he has referred to as a generic term for such distress. But I would want you to enlighten us more, because I know that even while Mr. Akiwumi was speaking, he mentioned that before CAMA 2020, the insolvency practice was seen as an undertaker practice. But we know that the Company and Allied Matters Act 2020 has introduced a lot of business rescue options. So please enlighten us. Let's know what all of these options are in terms of itemizing them, and let's know when and where they could arise or when they could be used. Can you hear me, sir? Leonard Silk, sir. Okay, we can hear the Leonard Silk. Maybe I would come back to that question. And Mr. Akiwumi, we may have to have you until he rectifies his.
Okay. I'm here.
Okay, so I don't know if maybe you want to respond to the question I asked, so that we know when these rescue options, when they arise and when they come in, because we know that it's not all the rescue options that were provided for or that are provided for in CAMA that you use all at the same time. People get confused. Some people confuse one business rescue option for the other. So it would be good for us to have an insight so that it gives us a clear understanding as to when each of these options could be used and when they arise.
Well, the options that we have, for example, where you have a liquidation, and it means that the assets or the company, in your opinion, cannot be turned around, and is best and cannot trade its way out of the problem that it finds itself. And therefore, you would quickly. Oh,
can you hear me? Yes, can I go?
Let's.
No, sir. It's still breaking. Or maybe if you turn off your video, maybe it may help with the connectivity, because it's really breaking up.
Should I keep trying until he comes? So
Yes.
maybe I should just try and
yeah.
yes, maybe I should just speak to the various options that we have. Receivership. That's where you have a secured creditor with a fixed or floating charge. And that appoints a receiver or receiver manager I'm sure maybe in the course of this discussion we'll show the differentiation or the difference between those two to realize secure assets and satisfy the debt. I must say that this is not, it's usually creditor driven and it's usually asset focused. Sometimes you appoint a receiver over certain assets of a company, even not entirely everything. So it's not rescue orientated. It's usually to get the money for your appointer. So you are agent of your appointer. So if your bank appoints you as receiver, your objective is to go in there, either sell the assets if you're just a receiver, or run the company if you're a receiver manager and it's possible to run the company, to sell or to get the income and pay your own appointer. So you're the agent of your appointer. And when I say that, it's satisfy the debts focused. It's creditor driven, and it's not rescue orientated. It may end up in a rescue, but that is not the objective of a receivership. The second one is the administration. This is a formal rescue mechanism, and it's always been there, sort of, but it was robustly introduced by CAMA 2020. And an administrator is appointed either by the court. By the way, a receiver can be appointed by the court as well. I just thought I'd drop that in. But an administrator is appointed either by the court, the company, or the directors of the insolvent company itself. Or maybe there's a floating charge that somebody has. So we call that a qualifying holding charge. So the holder of such a charge can actually appoint an administrator to manage the company's affairs. Now, the primary objective of this one is to rescue the company as a going concern, to achieve better results for creditors than a liquidation. So, you always have the option of a liquidation anyway. But if you look at it and say, look, maybe the problem we have is that, as I know in one company, the 3 or 4 brothers running the company, they took it over from their father. But the 3 brothers could not agree on anything. They couldn't agree on the time of day. And that was a big problem for the company that had good potential. The one thing that they then agreed on, somebody went to court and said, look, can we appoint a receiver? And even then they fought about it, but the court appointed the receiver for them. So, and the objective was to rescue the company, so pay off the debts, because the company was a good company anyway, and restructure the company properly, pay off the debts, and the company went back out of insolvency. If they had sold the company, they probably would not have gotten as much as they got from the administration. So the third one is a company voluntary arrangement, popularly known as a CVA. I'm very proud to be one of the first, if not, I think the first, who did a CVA under the new CAMA. And I was appointed nominee alongside another of our distinguished BRIPAN EXCO members, Mr. Kalu. But this allows a company with or without a moratorium to propose a binding arrangement with its creditors to restructure its debts. So in the one we did, it was a hotel chain. And because of COVID, and nobody could go out, and nobody, even when they were allowed to go out, nobody wanted to risk going to hotels. So while the hotel was still running, it couldn't do business as it would. But it had gone into credit arrangements prior to COVID based on its previous business running. And at that time, they realized that if the interest was running, if they didn't enter the arrangement with the creditors to stop that interest or pause that interest, then the company will go completely, it will go down completely. So they decided to have a CVA, hence our appointment. I must note that it requires approval by 75% in value of the creditors. So it's a consensual, flexible tool. The CVA is the third option. The first one is probably one of the ones that were most popular, winding up a company. Once you have the debt and you pay, in the old days, it was more than, once you have pay 200 naira and 3 weeks pass after you give notice, you go to court asking for a winding up order. It's become less attractive because what happens is that people then go to court and start disputing the debt. And one of the things about the law is that the debt amount must be definite. So I say you're owing me 10 naira, and you say, no, it's 9 naira 99 kobo. And therefore, you can't wind me up. So it's less attractive, but in some cases, it's the only way out. And sometimes even the company itself has voluntary winding up. Then there's also netting agreements. CAMA validates netting arrangements in financial contracts, which is particularly relevant for capital markets and financial institutions. So you can net off this a particular transaction or particular debt against one another. But I think that the most important thing here is that CAMA 2020 has moved from liquidation first, the idea of liquidation first, to the idea of rescue as the first option. And I think that, that's my perspective. Thank you.
Thank you so much, Mr. Akinwumi. We have the learned Silk back here. I'm sure he can respond to some of our questions now.
Yes, thank you very much. I hope you can hear me very well. Apologies.
Yes,
for this small technical issues.
It's very clear. So, learned Silk, Mr. Akinwumi has given us an insight into the use of the terminologies, insolvency, bankruptcy, when business rescue options, arise, and has also just helped us to itemize the different business rescue mechanisms under CAMA. So I would want to get your perspective. Do you think with the introduction of these business rescue mechanisms under CAMA, it has reshaped the insolvency practice? And while, responding to that, are there unique risks in cross-border insolvency involving Nigerian entities, particularly as regards the introduction of the CAMA 2020?
Yes, thank you very much, Ifusha. And I also want to express my own appreciation to the organizers. In the first place, I want to really state clearly that there has been a lot of improvements with the introduction of the new options under CAMA 2020. Before CAMA 2020 came into force, the insolvency options were limited to receivership, receiver management, and liquidation. And with the coming into force of CAMA 2020, there has been introduction of administration of companies. There has been introduction of the company's voluntary arrangement, as well as netting. And in all other options, again, among practitioners, again, there's been a lot of improvement in the manner which most of these options are being administered. Clearly, this has helped to reshape the corporate environment in Nigeria, particularly with regards to credit and also management of all those credits being extended by creditors to businesses in Nigeria. Now, if businesses are having challenges, there are a number of options that can be considered, particularly with special interest to the particular issue that has arisen in that kind of in that particular business. Now, under the new CAMA 2020, again, another very interesting introduction under the new CAMA is that there is now certification of practitioners. It's not every practitioner that can now hold an insolvency office. You are required to have the necessary training and certification from CAMA for you to hold all those insolvency offices, which are created for administration under the options, like to become an administrator, to be a nominee, a supervisor, even a receiver manager. Post CAMA 20, you require such certifications. Thank you. I can't hear you very well, Fosa. I can't hear you.
Oh, sorry, I didn't know I was muted. I said thank you for that introduction. I was asking if we have unique risk, because the topic the topic also borders around risk and the revolution of resolution and recovery of businesses. So I was asking if there are unique risks in cross-border insolvency that involves Nigerian entities.
Well, the challenge with cross-border insolvency is that, don't forget, with every jurisdiction, there are limited provisions of laws that must apply with regards to those jurisdictions. And then with cooperation among nations, what has happened is that with the introduction of the UNCITRAL model law on cross-border insolvency, the application is limited to those countries that have adopted the UNCITRAL model law. So the effect is that an insolvency matter being commenced in a particular jurisdiction can enjoy some benefits and advantages in other jurisdictions, provided there is cooperation and also incorporation of those laws among those jurisdictions. But where difficulties may arise is where most countries have not adopted the UNCITRAL model law for particular reason, and then it becomes very difficult to enforce an insolvency process commenced in a particular jurisdiction in another jurisdiction. But with a lot of countries now embracing some bilateral contract arrangements through treaties, and also having multilateral arrangements, particularly with regards to some judicial processes and insolvency administrative processes, as well as other particular areas of commercial practice, you can now find an easy process whereby a decision in one country will be given effect in another country. So to that extent, they can try to have some solution to those kind of challenges. But again, where countries have treaties that guide either their insolvency processes and other processes, it's very easy for an insolvency practitioner to achieve substantial benefits, particularly with regards to enforcement steps in insolvency in other jurisdictions. So the practical situation can be found in where a particular court in a jurisdiction makes an order which you don't need to, all you need will be to comply with the enforcement processes in the other jurisdiction to allow for such enforcement. So an insolvency, a commencement of an insolvency process, let's say a liquidation in Nigeria, can be given effect in another jurisdiction where they have some uniformity in enforcement of those processes. So with that, they can be able to overcome some of those challenges. Another area has to also do with tracing of assets, where you may have to be confronted with local legislations and enforcement provisions regarding to tracing of most assets, and which of course you issues of conflict of laws may come in, and it's important for the practitioner or the insolvency office holder administering a process in a jurisdiction to be able to work with another insolvency office holder in another jurisdiction to achieve good results because of the differences in legislations, the differences in procedural rules, and as well as other regulatory requirements which may be introduced within that particular jurisdiction. But ultimately, with the relationship with international, in terms of international associations, and then with more practitioners embracing membership in all those organizations, it's quite easy for them to be able to relate with one another and achieve a common purpose with regards to any particular process. Let's just give an example with what we have in Brighton and Insol. You know, I have had a challenge of trying to relate with some professionals, you know, but with the help of a common membership within the larger organization, which is the Insol, the International Insolvency body, it's very easy for us to, you know, work with our members in other jurisdictions in different parts of the world. You know, so with that, professional relationship has, you know, tried to build bridges across some of those barriers.
Thank you so much. Mr. Akiwumi, so I'm coming back to you now. With your experience in insolvency, and I heard you mention your experience too with the CVA as a pioneer insolvency practitioner who attempted after CAMA 2020 to use that business rescue option of the CVA. Are there specific industries where one can identify this heightened distress? And while mentioning if there are specific industries, even for the directors or the officers, what legal risk do they face when a company is approaching insolvency?
Yes, of course, there are various areas of the economy which are more susceptible, it appears. I don't know if anybody has done any survey, but I speak from my experience and observation. Because Nigeria's economic landscape over the past few years has meant that distress is not evenly distributed. I used to have a theory in the early years of my practice that all those people who went to borrow money from banks, at least most of them, had no intention of paying back. And because over the years, we actually saw the business plan, the risk plan from the bank, and you have people who took money from the bank and went to marry 3 wives or 2 husbands, or had the business plan to build a business and took the money to go and build a mansion in the village because he wanted the chieftain's title. So I had that, but I think that the walls have closed in on them a lot more, and therefore a lot more people intend to pay back, but sometimes they're not able to. And I think the sectors that have been most hit have been, and in no particular order, the banking and financial services. You know, there have been a succession of recapitalization directives from CBN. The foreign exchange has gone up in the past, has gone from, in the past 5 or 6 years from, I think, threefold. That volatility has not helped at all. Although lately, thank God, at least there's a bit more stability in that regard. And so non-performing loan portfolios and the exposure to distressed sectors by these financial institutions have placed them under pressure. And that has made banking and financial services, one of the sectors. Another sector, of course, is the real estate. Real estate is really a boom business generally, once you have capital. What has happened lately, especially in middle level of that industry, has been a lot of the costs have just gone up crazily. Some of those expenditure is in foreign exchange, yet you sell in Naira. And the projections may well be of a particular profit. And the exchange rates, the inflation wipes it out. And there's just no way to recoup. And we've seen major real estate and construction insolvencies in recent past. Oil and gas. And I sit here, I'm sitting as an IP on at least 4 oil and gas companies. And for various reasons, pipeline vandalism, production disruptions, transition, people are moving away from fossil fuels to, other things, especially in the power sector. The foreign exchange affects that as well. So that is another sector. The fourth sector is aviation. You've seen airline collapses and near collapses. I got a message this morning, for example, and I don't know if I can see it, but anyway, basically what it says is warning us that from Monday, we should expect, if anybody wants to travel within Nigeria, we should all expect disruptions because of the past 2 months of high jet fuel costs. So all of that has also affected that sector. And of course, manufacturing, with lack of power, with foreign exchange scarcity, change in the rules of obtaining foreign exchange, it's been difficult. Same with consumer goods, retail, imports. All of those have a big impact on those sectors. That's not to say other sectors are not affected, but I think those are the primary ones. Now, as to what risks do directors in particular officers, because you can have a CEO, the director, directors and officers, but directors in particular, when a company is approaching insolvency, the law recognizes that there are indices inside the company which indicates that the company is heading for insolvency. Certainly, you have to have your annual audits. You have quarterly business payments and all sorts of things. So essentially, companies know where they're heading in the wrong direction. And CAMA recognizes it. So CAMA said, look, you know what? There's something called wrongful trading, or some call it insolvent trading, where a company goes into an insolvency. And remember what I said, that you may not have any receiver or any order against you, but you know that you're insolvent. So when a company is insolvent, it can't pay, it can't meet all its obligations to its creditors. Any director, and I think this is very important, any director who knew or ought to have known that there was no reasonable prospect of avoiding liquidation or insolvency liquidation or insolvency, and failed to take every step within his or her power to minimize losses may be held personally liable to contribute to the company's assets when insolvency comes. So if you're a director, you can see that this is going south and you fold your arms without doing anything. You don't query the board, the CEO or the managing director. You don't ask questions. You don't try and you don't host the sinking ship. When the time comes, you will be called into question. That's wrongful or insolvent trading. You also have fraudulent trading, where business is carried on with intent to defraud creditors. Directors face both civil liability of the insolvency and criminal prosecution. So the standard there for that one is dishonesty, but courts look carefully at the conduct in the period preceding insolvency. So fraudulent trading, you want to, some companies then pass assets to a sister company and sell that way. And, there's all sorts going. I could have a whole speech on that. So, but fraudulent trading is also something very difficult. Now, when you're a director, you know that you owe a fiduciary duty, not only to the company, not only to the shareholders, but also to your creditors. And when an insolvency approaches, the law recognizes that you must shift your primary duty. And I like to emphasize this. You shift your primary duty from acting in the best interest of the shareholders to acting in the interest of the creditors. So I say that again. You shift your primary duty from acting in the interest of the company, basically, to acting in the interest of the creditors. Therefore, you won't do wrongful trading. You won't do fraudulent trading. But if you don't make this shift, so example, you are paying dividends when you're insolvent. You're transferring assets to other companies because this one is going insolvent. And you know that it will then be difficult for creditors to reach those assets. Or you're preferring connected parties. So I'm giving CVC because I know that CVC, I know a friend, giving him the contract to do something and get the money and pay him in advance. It exposes the director to claims, adverse claims. Then preference and ancillary transactions. So you sell assets at undervalue. You give fraudulent preferences. You give credit that you know cannot be paid back within a prescribed time, 12 months before insolvency comes in. All these transactions can be challenged. And the directors who are behind it may face personal exposure. Directors of insolvent companies may be disqualified for acting as directors up to 15 years. And then in the regulatory, various, CBN, SEC, NICOM, regulatory sector, even as lawyers, they may be subject to personal sanctions from those bodies. I'll leave it at that at the moment. Thank you.
Thank you so much, Mr. Akiwumi. I would want our responses to be a bit faster now because we just have about 10-15 minutes to run through this meeting.
Yeah, you have two questions in one. That's why I was long.
Yeah, yes, I know. I know. So I want the audience to really appreciate this, having two distinguished insolvency practitioners. It doesn't happen all the time. So at least I enjoy the session. So let's see, sir. Now let's go into the issue of the disputes that could arise from insolvency. To what extent are insolvency disputes arbitrable under Nigerian law? And where do conflicts typically arise? between the arbitral tribunal and the insolvency court. And why you're sorry, sir, why you're answering that it would not also be a bad idea to explain to us, given the doctrine of separability, can those clauses truly survive insolvency and how enforceable they are in practice? So it's like a two-in-one question, but it's just to save time so that we get a grasp of the conversation properly.
Thank you very much. No doubt that the alternative dispute resolution by way of arbitration has created a more and better, I would say, a better way of resolving some disputes. But again, we must be able to appreciate that there are elements of contracts in both situations. Arbitration is based on contract, whether it's post dispute arbitration or pre-dispute arbitration contracts. Now, insolvency has a lot of elements of contracts, but substantially it is guided under the provisions of the law, which also creates circumstances where the respective interests can explore the use of any insolvency option in any dispute or in any major commercial challenge by way of indebtedness. But the interesting thing to note is that sometimes practitioners have been able to devise means to manage it in a complementary manner, in the sense that, for instance, an insolvency office holder can enjoy some benefits by addressing the some of the issues he may have in administering, let's say, receivership or liquidation and administration, to allow for those engagements or issues arising from them to be resolved in a manner that will lead to a win-win situation for all the parties. Because insolvency will certainly arise either by some failed obligation in a contractual relationship, let's say a debenture, or some other charge, or some credit arrangement, which will give the creditor or the lender the right to adopt a particular insolvency option, maybe by receivership or receiver management or administration, or even liquidation, as the case may be. But in the course of conducting this process, the insolvency office holder must also appreciate the point that at different times he may have the need to engage for intervention with the court. He may have the need to engage with other interests like employees, respective creditors, and also regulatory authorities in the course of administering the process. So to that extent, arbitration or alternative dispute resolution can come in depending on the manner in which it is applied to be complementary to the insolvency process and now allow for greater benefit for all the interests. Now, all this, where there are issues or challenges in insolvency, you also have internal mechanisms within the process, like a situation where you already have an engaging process or management of that particular company that can help resolve it, or some interventions that you can resort to in the through the mechanisms of the court to come in and give some judicial intervention by way of reliefs or orders that will enable effective continuity in that in the insolvency process. But again, let's not forget that in arbitration, yes, there is a lot of confidentiality, there is speed. We have the advantage of using the best experts. It's private, and again, is party driven, and again, they can manage their costs. So in such situations, we have instances where a court-appointed administrator is confronted with an arbitration contract which requires that at least where such dispute should have been submitted, to arbitration before the court can appoint such an administrator. The court may not give due regard to that because the option is created under the law, and between a contract and a legislation or an act of the National Assembly, of course, we know that the provisions of the contract will prevail over mere contractual arrangement between the parties. But again, in such situations, it's advised that principal parties or the insolvency office holder should be able to manage all the interests, to, particularly if it has to do with administration, to ensure that the result becomes of mutual benefit, since it's collective at the point of dealing with each creditors. Because even in administration, you have a collective process whereby in addressing the objective, which of course has its objective as either you focus on rescuing the business of the company, or providing an enabling or ensuring that better results are achieved for the creditors. Because one critical thing about administration is that in most cases you must focus on the objective of that arbitration administration. It may well result that the owners of that business do not intend to continue with the business, but their main challenge is on dealing with the indebtedness of that particular entity. So you try to ensure that you are guided to achieve that particular objective. But where the owners of this business intend and wish that this business can be rescued, then you have those two objectives to be able to pursue one simultaneously. And to that extent, the engagement of the relevant experts that will be able to assist you to achieve that result becomes of utmost importance, in the sense that should it result to issues of settlement of internal dispute or some external dispute or some intervening judicial processes that can come in. Because presently, for most insolvency litigators, if I may just use the word, they will see that there is some sort of increased litigation in our courts, particularly resulting from some insolvency process or the other. And again, it's quite unfortunate in that regard, because ideally insolvency is intended to be purely, at least up to 85% administrative, so that the courts or mechanisms of settlement of dispute can be deployed at only very crucial stages where the benefit will be for the interests of all those parties, as well as the creditors involved, one way or the other. But because of the deployment of different options, like I've mentioned, the option of receivership and management, the option of receivership, administration, companies, voluntary arrangement, and then liquidation. Now, these are different circumstances. And then the management of some of the issues that can arise in these circumstances require, to a great extent, expert knowledge of whatever mechanism or tool you want to deploy at every stage. And it also allows for engagement and employment of other professionals. A particular insolvency process or will require the need for engagement of other professionals like valuers, like secretaries, like lawyers, and other experts that you find relevant. And then where situations allows for having a special manager to deal with certain issues in that entity, again, you must also appreciate the need to engage one that has the capacity and the knowledge to deal with the issue. But using in terms of arbitration and insolvency, I think they should be employed in a way that it will be complementary. Bear in mind to understand where to draw the line, because one thing is clear: arbitration can result through a contract. In exceptional circumstances, there are laws that have also provided for the use of arbitration in settlement of disputes. But taking the special nature of insolvency regime and the options provided under the CAMA 2020, one must appreciate how the deployment of these options can provide better benefits for the interest. And in most cases, like a situation where you have a receivership confronted with an arbitration clause and an insolvency option in a security or in a credit instrument, the creditor or the beneficiary of such credit instrument will be able to examine that instrument and decide on the one that will provide the better result under the circumstances. And most times, again, where those credits are being sourced from or other jurisdictions, and then it gives some added challenge that you must be able to also engage appropriately to ensure that those results are achieved. Thank you very much.
Thank you so much, Lynette Silk. So now I'm back
I think you are muted.
No,
Can you unmute?
No, I'm not muted. Can you hear me?
Oh, sorry. Yeah, okay. I can hear you.
Okay. So I'm back to Mr. Kiwumi now. So in less than 2 minutes, Mr. Kiwumi, just give us an insight with your experience in insolvency. We have litigation, we have arbitration, we have other dispute resolution mechanisms, particularly alternative dispute resolution. Which do you see really prominent in insolvency and business rescue context? And while answering that, it will be good to suggest or recommend reforms that could strengthen the Nigerian insolvency and dispute resolution framework if it will be beneficial in promoting and growing our economic space.
Okay. Your question itself is almost 2 minutes. You're asking me to answer it in less than 2 minutes. Well, honestly, litigation remains the dominant mechanism in Nigerian insolvency and business rescue disputes. That's because, of history. And there's not been enough institutional dynamism. And also because of our culture. I keep on telling the story of when I was appointed as an administrator of a company. I was acting for a company that was being owned by an international company. And I went to the company in the UK where they had an administrator. And the MD, the actual MD, was sitting on one side of the big room, a big office, and the administrator had his own table on the other side. They were working together. So the nature of the proceedings itself make room for litigation rather than arbitration. I've heard a lot from the London Silk. However, I must be honest that the trend is shifting, albeit slowly, and several factors are pushing parties towards arbitration, because now the business world, you have to pay tax and all these things. You're looking to get your money as soon as you can. So there's the ADR, and institutions like CIR has helped a great deal. When we have in our agreements that the president of CIR appoints an arbitrator, it has generally been respected institutionally, and therefore that has helped a great deal. If the institution was not respected, we would have less of this shift. Arbitration is increasingly used where the underlying commercial dispute arises from a contract with an arbitration clause. So yes, we've seen that move. But the funny thing is that even mediation, I've been involved in a couple of mediations and I've been quite astonished. I went into them with a bit of skepticism. But at mediation level, we've been able to solve some insolvency disputes, and that has helped us a great deal. So for me, I think that litigation is number one, arbitration is slowly creeping in, and mediation is also following. The second part of your question was?
What do you recommend as a reform that could strengthen the Nigerian insolvency and dispute resolution space?
I think that already there's been a lot of reform going on. And I must commend the Leonard Silk CVC, the immediate past president of BRIPA, and your good self, of course, for the work that was done in the last regime of actually engaging not only just the Federal High Court, but also the institutions and seeing and having these discussions. I think that inertia that they hitherto had has moved a bit more. So that's one thing. The other thing is that there has been some change from the Federal High Court, and I mean I understand that even in CBN there's something in the offing where you have to have gone to try and resolve out of court first before you can come to court. So those sort of things would help the institutional dynamism. Thank you.
Thank you.
I tried.
Thank
3
you so
minutes
much.
or so.
Yeah, you tried. So Leonard Silk, now your own is 2 minutes too. But I'm going to ask you a question that I know it's a comfortable space. Mr. Akum has just referred to the reforms you introduced during your administration as president in BRIPAN, and it's a recurring challenge that we see as litigators. So my question is, what challenges would usually arise when enforcing arbitral awards against insolvent Nigerian entities? So while answering that, you now recommend the lessons as Nigerians that we could draw from the international space, given the best practices such as the UNCITRAL model law and the cross-border insolvency in that area.
Thank you very much. All I can say, thank you, Mr. Sheyi Akiwumi. Well, the truth is that we must accept the fact that this area of law is still developing. One point which I must emphasize on, which we appear to have neglected, is in terms of professional obligations. Arbitration, for instance, is based on contract, where parties agree on a particular means of resolving any dispute. And ideally, sometimes when matters are taken to court to set aside an arbitral award, it's quite surprising because we neglect we must be able to, as professionals, help to inculcate in most of our clients and persons and interests that engage us the setting position of contract. Because if you believe in contract, ideally there shouldn't be any reason why a dispute being resolved by an arbitral award, which you have selected and chosen by yourself, will be taken to court. So we must now, at this stage, begin to look at those professional obligations. I think the problem lies in ourselves by ensuring that ethical and contractual values, which call for us to follow in our professional calling, are neglected. In other jurisdictions, there are cases that you bring to court and you are taken before the professional organization or the regulatory or disciplinary panel to deal with it, because one will begin to wonder why such matter will be taken. Then again, taking insolvency in relation to arbitration, both should be complementary in the sense that, one, if you are dealing with interests of creditors, you must understand the rules relating to priorities and rights of that particular creditor. Even where he has an award, he has a judgment. There's no difference between an unsecured creditor and a judgment creditor or a beneficiary of an arbitral award. So they enjoy the same level. So most times it is always it's better for the insolvency practitioner holding that particular office to be able to appreciate, one, is a collective process. But again, there are limited rights that can be exercised by all the interests, including the employees, including those who are engaged as independent contractors in a particular process. So whether you are conducting a complete voluntary arrangement or you are conducting an administration, or there is even some challenge of the process in court, which again leads to what Brightpan tried to do in working with the Federal High Court, working with regulatory institutions, for us to have common positions, so that when these matters are being initiated, the court will be in the best position to appreciate and then give the right decision. It is not the normal litigation. These are processes that are not only regulated based on contractual values, they are also regulated by the institutional and then the legal framework that guide it. So due knowledge is required to deal with it, because a number of times insolvency processes are being challenged, arbitral processes are being challenged. Now the question is that for professionals, to what extent have they been able to achieve the result? If you check the cases, you will see that there's hardly I can't remember any award that was set aside by any court in Nigeria. I'm not saying it does not exist. What it shows is that people just go to court. And this is a contractual obligation that is very simple. The same applies to insolvency. Insolvency arising through a judicial intervention must respect the interest. So it's not enough that an administrator is appointed. Like we have a situation, which of course, because the case is live, I'm not going to mention them. But we have situations where in the course of that process, there are agreements that retain arbitration clauses. There are interests that require some level of protection. And we are hoping that at the end of the day, the decision that the court will give in that matter will be able to accommodate all these interests and help in shaping the insolvency and arbitration space in Nigeria. So it's always good for practitioners to recognize that then where you have limitations or where you believe that the exercise of your right is restricted under the law, you should be able to apply the best options to deal with it. Because ideally, in countries that have embraced effective arbitration and insolvency processes, have attracted a lot of developments, not only within the society, but again, in the conduct of transactions among enterprises. Thank you very much.
Thank you so much, Leonard Silk. I don't think we would have done it better than our two seasoned speakers that we have before us here. Because of time, we would want to go to questions and answers. I only have one question here. If you have a question, please drop it in the chat box. I will take the questions one after the other. And once I see that we do not have much time for this session anymore, I would stop. So please drop your questions. So it's fastest fingers. So the first question is from Deborah Chikwendu. Her question is that, is it not prudent? Please, when asking your question, you can direct it to the speaker you want to give a response to such a question. Is it not prudent that while we encourage the adoption of the UNCITRAL model law, we at least first enact an Insolvency Act? I would want the Lenesi to take this, because I know this is his area and he just spoke about certain reforms with the courts.
Thank you very much. In the first place, yes, we have the UNCITRAL model law, which are being applied by a number of countries. Now, it is not, I must state that we must look at and consider what works within our local environment. I'm not completely in full support that we should go ahead and embrace the UNCITRAL model law without, understanding the advantage. There are countries that are also participating in discussions and the debate at the UN on UNCITRAL Group V, which is the group at the United Nations that regularly discuss and update the model laws for those countries that apply it. Now, the fact that we have not adopted the UNCITRAL model law does not mean that there are no advantages that accrue to Nigeria as a nation. I have had an engagement which was cross-border in liquidation, where we also took benefit of the unsecured model law because the country where the assets are being traced to had adopted the model law, and they had the provisions that allowed for recognition of not only our insolvency process, which was by way of liquidation, but also by recognizing the insolvency office holders. And we enjoyed every benefit within that jurisdiction. But the difference and the challenge is that because Nigeria has not adopted, they will not have similar privileges within this country. So, and most times, what actually works for country A may not work for country B. So in most cases, we must be able to see whether bilateral agreements by with countries or states that we regularly have business transactions with, or multilateral arrangements can be able to assist in the sense that a decision given in one jurisdiction will create the comfort in another jurisdiction without having to initiate that process again. So, but if we look at the unsecure model law, of course, BRIPAN under the tenure of Chief Idigbe, Senior Advocate of Nigeria, and Shola Oyetayo, subsequently, produced the insolvency bill, which tried to incorporate the aspect of the unsecured model law on cross-border insolvency. Unfortunately, that law is yet to see the light of the day. But again, what we did was to be able to look at ways that advantage and benefits can accrue to Nigeria. And we accepted the position that it will be of benefit to the country. And that is why we presented it. Yes, the law was passed at the lower house, but unfortunately, it was not signed into law before the last administration left. Efforts are being made through the Legislative Committee of BRIPAN to push further those laws. And in addition, again, a number of practice directions have been proposed to the Supreme Court, to the Court of Appeal and the Federal High Court to enable and support these processes, particularly where you have to conduct processes, insolvency processes to ensure that all those interests affected are protected. So I don't know, I believe I would have been able to capture some of it, but if not, I don't mind giving more clarity on any aspect. Thank you very much.
Thank you so much, Leonard Silk. I don't know if there are any other questions. Okay, I can't see any other questions. I don't know if in a minute or two, no, 2 minutes would be too much. In a minute, I don't know if past presidents or Leonard Silk and Mr. Sheyi Akurumi, I don't know if you would be able to tell us a short war story or any. Okay, I think a question has come in. Okay, a question has come in, so we may not go into that. Mr. Sheyi Akurumi, this question is for you. What do you foresee as the emerging trends in bankruptcy and insolvency disputes in the next few years besides ADR, which you spoke extensively about, and how can businesses prepare for the evolving landscape of financial distress and insolvency laws?
Okay, sorry, just a second. Can you hear me?
Yes, this is from Jumoke Adio.
Yes, okay. The emerging trends. I think that in the next few years, we'll have a lot more in-house preparation for potential insolvency of companies. So I'll talk to bankruptcy later. But I think we'll have a lot more better preparation. We have companies in the UK who have departments who are internal regulators, so that we are able to prepare for the potential of insolvency. And the reason I say that is there's a lot more focus on directors. And when the director's liberty and personal business is at play and is threatened, then I think there will be a lot more corporate attention paid to internal corporate governance of those businesses. I think that is going to be a lot. I think there will be a lot more litigation against individuals, individual directors, by parties and by institutions. Now, with regard to bankruptcy, I think that I see a move towards bankruptcy proceedings a lot more. I've had a few instructions recently, which ultimately didn't end up in us undergoing bankruptcy proceedings. But the fact that they're coming to us now to discuss it tells me that a lot more people would see bankruptcy proceedings as a way out of particular experiences. You also asked for how can businesses prepare for the evolving landscape of financial distress and insolvency laws. Honestly and truly, companies, the uncomfortable truth is that businesses fail. And they fail for various reasons. Bad markets, bad decisions, bad luck, or a combination of all three. So you can't always legislate for everything. But I think corporate governance, internal checks can help to prepare you for potential financial distress. And I know some companies who actually have started to employ insolvency practitioners before they become insolvent to advise them. We've had to advise a company at the end of last year. We're quite surprised. They're doing very well. And but the managing director explained the reason for his advice. The advice he sought from us. So I think those sort of things will begin to come into play as we go along. Thank you.
Leonard, your hand is raised.
Yes, I just wanted to point out. Thank you, Mr. Kiwi. I just want to add to his intervention that we must. There's a lot of we need to strengthen our judicial system, the courts, in terms of training, in terms of the institution, because ultimately, under the Constitution, insolvency matters are exclusive preserved for the Federal High Court. It retains that jurisdiction. And at most times where interventions are needed, it comes through the structures of the Federal High Court. Recently, we thank the court for having established the insolvency division, whereby most matters are being resolved. But again, by establishing such insolvency division, which is only active at the Federal High Court, we have the Federal High Court in in most of the states, at least, of the Federal Republic of Nigeria. There is need to extend the effectiveness and the structures of that office to all those divisions. In addition, again, we must ensure that those persons who hold those offices, occupy those positions, have the benefit of good training, which must be continuous in terms of development. Because, this is an evolving area, a developing area of law and practice in Nigeria. And if successfully managed, we'll be able to bring good benefits. So we can't just leave everything to practitioners and businesses. Yes, I agree with Mr. Akinwumi. There is need to strengthen the internal corporate governance structures within the system. But again, where there is intervention, where do you go to? The court. If the court has lacked the capacity to deal with a particular matter, they cannot give you the a good benefit in terms of justice delivery in insolvency matters. And again, looking at the structure of the court, for instance, the fact that most bankruptcy matters are not heard of does not mean that it's not an active area. It's a very active area of personal insolvency. But the truth about it is that because of the negative perception of bankruptcy, once it is commenced, most times it leads to early settlement. Most parties resolve those matters before they get to the stage where someone is being adjudged to be bankrupt or those procedures. And again, they are resolved through alternative process. And because we don't get to hear about it, does not mean that it's a very active area. A lot of persons resort and apply it. So in summary, I think we need to strengthen the court system and as well as the structures within the court system. Our judges need effective and satisfactory training to administer these two stages. In a country like England, I remember when the African Roundtable 2010, which was hosted by BRIPAN, interestingly, Mr. Sheyi Akinwumi was the president of BRIPAN at that time. He hosted the African Roundtable, and the judge that was came, to one of the facilitators, a judge in England, he told us that insolvency appeals are hardly heard of. So what it means is that at the conclusion at the High Court, once an insolvency process is being determined by the court, you can hardly get an appeal. So what it tells you is a very effective and efficient system that from the registrar, from the judge, and even among the lawyers, they understand the system. And because there are consequences too. As a practitioner, there are things, you have limitations on what you can do. It's not here where there are no consequences. With due respect. Thank you.
Thank you, Leonard Silk. I was just trying to signal to you that our time is fast spent. I must commend and congratulate and thank our remarkable speakers for such an insightful and memorable session. Just a way to end this session before calling on the past chapter secretary or branch secretary, Mrs. Josephine Akinwumi, who will be representing the chair of the Chartered Institute of Arbitrators Nigerian branch to give a vote of thanks. I would just want to conclude with the comment from a Kenyan audience so that we know that we are not just Nigerians here and we have people from Kenya who have joined us. And the person is Akot Alochi. And he says, from my experience practicing in Kenya, he's an arbitrator and a commercial litigator. While the right to initiate insolvency proceedings is statutory and cannot be ousted, there is a strong case for courts to take more deliberate role in preserving the integrity of arbitration agreements and the outcomes, particularly where disputes fall squarely within the contractual framework already invoked. So from a practitioner standpoint, if this calls for a careful balancing act, then let's weigh in the sanctity of arbitration, the collective nature of insolvency, and the risk of individual creditor action disrupting structured resolution efforts. So I think this is a good way to end this session, and I'm sure we all had a memorable time from our speakers. It was very insightful. I will now call on the past branch secretary, Mrs. Josephine Akinwumi, who is also a fellow of the Chartered Institute of Arbitrators Nigeria branch, to give a vote of thanks. Thank you.
Thank you so much, Efosa. Indeed, this has been an insightful session. I was almost thinking that if anyone came on this webinar without having a clue about what bankruptcy and insolvency disputes were, I'm sure they're leaving better equipped. And so on behalf of the chairman of the Chartered Institute of Arbitrators Nigeria branch, I'd like to say a big thank you to Leonard Silk, Ihekweazu. We're extremely grateful. and Mr. Asheyi Akinwumi. I was looking at the time and actually saw that we spent about 1.5 hours here. And we do not take this for granted. We're extremely grateful. We acknowledge the fact that in signing in, we had the glitches, but you made every effort, Leonard Silk, to be here. We are extremely grateful and we really, really thank you. And looking at the comment sections, the questions that have been asked, I know that indeed the participants, the audience have had an amazing time. And indeed, it has been time very well spent. We are grateful. And for our moderator, Efosa, Mr. Were, you've been amazing.
Thank you.
I recall when you were asking some of the questions, you had given the our speakers 2 minutes, and they said some of your questions were actually 2 minutes, and you did a good job. And so we really thank everyone for making out time to attend. I also noticed that CIAB has put on a list of some of our courses for our audience, and I believe there'll be calls, there'll be registration for you to take advantage of some of these courses. Thank you, everyone, for making out time to be part of this specialty training. And we look forward to seeing you on more of our webinars. Thank you, everyone, so much, and have a good afternoon. God bless you all.
Thank you
Thank
very
you.
much.
Thank you.
Thank you, everyone. Thank you.